We are now introducing case study based on actual cases we have worked on. Okay, so as advanced by Nick, many players might be involved in real estate transaction, in Italian real estate transaction. However, an Italian notary is always involved in any real estate transaction. It is a common belief also for Italians that since an Italian notary who is a public officer is involved in the transaction, everything is in order. We are showing you that it is not always true. There are many reasons. For instance, the notary cannot check all the features of a purchase. And also there might be some miscommunication between the notary and the parties. I'm showing you some notarized contract. You can see an example here with the name of the notary here, the stamp. However, we have changed sensitive information with fictional information for privacy purposes, of course. The first case study is related to a void notarized agreement of sale. Here is the case. You can see here two pages. Basically, it is the same page of a notarized contract. However, on the left side, you can see the page as you would see. On the right side, you can see the same page as we, as professionals, as lawyers, see them with the main points and issues and so on. So what about the case? Basically, two persons in 1995 purchased a property, and then in 2023 they found another person who was interested in purchasing the same property. Therefore, they went to another notary to notarize the property sale contract. However, it was found that the previous contract, the title, was void. I'm showing you this page of the second notarized contract of on 2023, and the notary says that the parties purchased the property in 1995 through a notarized contract. The notarized contract was recorded in real estate public registers. However, since the property, since this previous contract did not mention at all one of the buildings that were included amongst the properties to be transferred, and therefore, since one of the statements related to compliance, property compliance, was not included in this contract, and as per the law, it is mandatory to include this kind of statements in the contract under penalty of voidness. For this reason, the previous contracts, the notary says here that the previous contract is void. What happened? The sellers, these two persons, were confident that their title was in order because it was notarized, and also they did not make any change to the property in the meantime. What happened? We understand that there was some miscommunication with the notary. Indeed, in this contract, the notary says that this voidness was due to a mistake. There was a miscommunication because probably the parties did not inform the previous notary that amongst the buildings to be sold, there was just this small building, since it was a sort of barn or shed. So it was not relevant in their opinion for the transaction, for the entire transaction. However, they were not aware about the legal implication of this lack of communication with the notary, and this is why the notary did not include it in the previous contract that was void. So this is an example of how it is important to inform the notary about everything. The communication is everything in a real estate transaction. Now I'm showing you some notary's liability limiting clauses. Basically, notaries do not have the expertise nor the duty to check all the features related to a real estate transaction. And one example is related to property compliance. Indeed, as per the law, the property compliance shall be declared by the seller in the form of the affidavit, and the notary cannot check that the statement is true. In this contract, we can see that basically the notary, the sellers declare under their responsibility, also criminal, as per criminal law, that the property is fully compliant. And then the notary says that the parties acknowledge that the notary did not make any inspection in public offices nor on the property to check whether the state compliance statement made by the seller is true. We can find a similar clause here. This is the clause. The parties declare that they did not appoint me, the notary, to check that the property is fully compliant, and the part in red, they waive me, the notary, from any liability in this regard. So if these cases are related to features that cannot be checked by a notary at all, we are now showing some clauses related to features that the notary has the duty to check, because notary, as per the Italian law, has the duty to inform all the parties about any potential issues, how to address them, and in general, the notary has a consultation with all parties before purchase closing, so that they can be properly informed and have the proper time to make their own decision. And however, especially when one of the parties is not an Italian and does not understand the Italian language, and the notary does not understand this party's language, unfortunately, the first meeting happens just the day of purchase closing. So the parties are informed, especially the buyer is informed about all the legal aspects and potential issues just a day, few minutes before purchase closing, and through an interpreter who does not have any legal expertise. So it is so that the buyer does not have the time to address any potential issues. The first example is related to the condominium. In this contract, we can see that the notary, as per the law, informed that the parties that about the default rules related to the condominium as per the law. So you can see the number and the date when the law was issued, but not the specific rule applicable to this case. Basically, the default rule is that when the property is included in a condominium, a prudent buyer would, in a condominium, in this case, for the condo expenses, unpaid condo expenses of the last 2 years, is responsible, the buyer along with the seller, for the past 2 years. So this is why a prudent buyer would ask the condo manager to release a statement, a written document through which certifies that there are no pending condo expenses. Another example is related to squatter right adverse possession. As per the Italian law, it is possible to sell a property also without a title. However, in this case, this ownership should be based on possession, which for a certain time, and this possession has to meet some legal requirements. So this is why it is required that an Italian court acknowledge and certifies that the possession meets the legal requirements, and therefore certifies that that person is the actual owner of the property, based it as per the law. Unfortunately, what happened? As per the recent law, it is possible to sell the property also without, based on adverse possession, and without any court acknowledgement about this kind of ownership. This is, in this case, the notary has the duty to inform the buyer about the potential issue, because this is a risky purchase. What might be potential issues? Basically, in the future, it might happen that a third party might claim to be the actual owner of the property. So it will be challenging for the buyer to resell the property or to obtain a mortgage. So these are two examples of clauses in notarized contract where the notary informs the party, and therefore this is as per the law, he informs the parties about this risky property purchase and potential issues. So this is concluding my part about case study. And now Nick is talking about another case study.
Thank you very much. And I am bringing back up my screen. Thank you, Rafaela. And guys, you've seen people who have purchased a property in Italy know how long Italian property purchase contracts are at the notary office. They are like 15, 16 pages long, especially if you don't go there yourself and you need an interpreter. So finding these terms in a purchase contract at the day of closing might be extremely challenging, like you being warned about things that you should know, stuff like that. That's why you want sometimes an enhanced mortgage grade title check, because you have the time to really analyze what you're reading, to really see that, oh, what, there's no title? A bank wouldn't buy a property if there was no title in the past 20 years. There's an issue of a null transaction before from my seller, or the seller or my seller. I don't want to buy, or I might ask my seller to give me title insurance. There is title insurance option. There are title insurance options in Italy, are absolutely not common. So you need to ask for it. And in the purchase offer, once again, you're able to specify that you want a 20-year title check done prior to going to closing, X amount of days prior to closing, and that if anything is not per the perfect title history that a bank would accept, then you want either the seller to fix it or to procure title insurance. Title insurance is not that expensive. Sometimes sellers get scared because it's not common, as I said, and they don't know that it's actually pretty affordable. It can be anything between 900 euros to 1,500 euros. So yes, it's money, but compared to not going through with a deal that the parties have probably spent a ton of time on, is a preferable option. So my case study, and then this is the last part about case studies, and then we'll go to questions. My case study is something that many people don't know about. And what I'm talking about is actually a void purchase offer. Many purchase offers are void in Italy, which is incredible to hear, but it is what it is. So when is a purchase offer void? A purchase offer is void when the parties are committing to commit instead of committing to do the transfer. I'll give you an example, a scenario. So you visit the property, you like it, the real estate agent takes you to the agency, or perhaps they have the form right there for you to sign. You don't have with you your checkbook, your money. However, you sign the purchase offer, give, do a wire or give some cash, 500 euros, whatever it is, the situation. You commit with a small deposit. And in the purchase offer of that nature, done kind of on the fly, the parties agree to go and sign an additional committing contract, which in Italy is called preliminary purchase contract or compromesso, or contratto preliminare. And in that additional contract, they agree that they will go to closing. So it is kind of a three-stage transaction instead of a standard two-stage transaction. So Supreme Court in Italy has said that when you commit to commit, the first commitment is completely void. No, like if you decide to pull back, you will get your money back, or at least you could ask for the money back. The other party might not agree, so much so that people had to fight up to the Supreme Court to have that entitlement confirmed. You don't want to be in that situation where you have to battle your claim in court. So just be aware when you are submitted a purchase offer, make sure that it is not going to be void. So here is an example. You're going to have a purchase offer. If the purchase offer simply says the parties will agree to repeat the terms of this purchase offer into a preliminary purchase contract, then you want to change that. Otherwise, you'll be exposed. And one might say, well, who cares? If it is null, I will take my money back and whatever. Well, the seller, if they receive a better offer, they might sell to someone else and claim against you that the contract, the purchase offer was void without having any obligation with respect to you. So you want to actually lock the deal and you want to take the property off the market with a purchase offer that will actually persist. Now, how do you resolve a situation where you actually don't have right then when you are pushed and urged to sign a purchase offer, you don't have all the information that is actually essential for you to put in a contract before closing? Well, at that point in the purchase offer, you specify why you need an additional intermediate stage. If you say in the purchase offer, we commit that we will sit down and narrow down item A, B, and C, whatever those items might be, like we'll see what type of permit to extend the property we get, and we will define the price accordingly. Or closing will depend upon the tenant leaving the property. We will decide closing date based on that. We will meet at so something, and there is a specific legal terminology to do all that. So if it is not going to be a smooth transaction when there is purchase offer and closing, but actually you feel the need of a third stage, just make sure that it is properly incorporated. The language is properly incorporated at the purchase offer level. Otherwise, in the purchase offer, you make sure that you have everything you need that is important to you, because once a purchase offer is accepted, it is a binding contract, and if you pull back without any justification or reasonable cause, you might lose your deposit. So a accepted purchase offer is actually a binding contract itself. So you might as well have everything that is needed in the purchase offer and go straight to closing. It will simplify your processing tremendously. So that concludes the case studies part. The conclusions are: educate yourself, prepare, know what questions to ask questions. If something feels off, ask questions. There are never wrong questions. Ask for help too. Who can help me? You have the realtor always there for you. You have the notary. If the notary is available to talk with you, there are some notaries who are more available to talk with you. Obviously, it might be a language barrier. You can have obviously your own lawyer if the transaction is a little bit more complex, or if you want that extra level of confidence. And so that's pretty much it. But definitely do this before signing, before committing, because as I said, once you sign, once your offer is accepted, that is a binding contract. And you don't just lose the deposit, depending on how your deposit is defined, the language that the real estate agent has put in the purchase offer. That commitment might not be only a money commitment, might be actually a specific performance commitment. We have had clients who decided to pull back. They thought, oh, we'll just forfeit the 5,000 euros. I will let them go, whatever. Well, the seller might sue you to go through with the transaction. And we have had actually recently a case where someone found a better property they like. They let the first one go, went ahead and closed on the second property, and then they were sued. And because they had an asset, and the previous seller decided to go for damages. So definitely consult an expert before signing.